So yesterday, Governor J.B. Pritzker replied to the Naperville challengers in the U.S. Supreme Court, saying that the plaintiffs got it all wrong and that they have not shown a likelihood of succeeding on the merits, and also saying that the interests of the public outweighs the plaintiffs in their desire to try to overturn the state gun and magazine ban. Here is Hannah Hill, who raised this yesterday on her own Twitter page, letting people know about, their reaction, the National Association for Gun Rights, their reaction to the state's pronouncement here of saying that the plaintiffs don't have it right.
Hannah Hill, I just wanted to hop on here and bring y'all a really quick update on our lawsuit asking the Supreme Court to step in and block the Illinois assault weapons ban and the Naperville AR-15 sale ban. As y'all know, we took that to the Supreme Court and asked for an emergency relief for the citizens of Illinois, suspending the enforcement of these unconstitutional laws. Well, Amy Coney Barrett took the very unusual step of asking Illinois for a response. Basically said, now give me your best reasons why I shouldn't do this. That response was due today. I just finished reading it. And y'all, it is a whole lot of nonsense. It's the same tired gun control arguments that we have been seeing from day one of this litigation. AR-15s are not guns for the purposes of the Second Amendment. We're going to engage in interest balancing anyway, even though the Supreme Court said we couldn't do that, et cetera, et cetera. I just spoke with our attorney. He confirmed that there are no surprises in this. This was what we expected to see, and it is very easily answered. So we will be filing that response here in a few days. So stay tuned for more updates, and please, if you haven't already, click the link below to get involved and help us fight this case.
So again, that's Hannah Hill with her latest reaction to the state's filing in the U.S. Supreme Court in the Naperville challenge. So we'll be watching that closely. Again, the Naperville challenge could possibly lead to Justice Amy Coney Barrett possibly acting on her own to issue an injunction before the January 1st deadline to register firearms that are banned by state law in the state of Illinois, or people could possibly face a felony. So we'll still be watching that case to see ultimately what happens, but in a separate U.S. Supreme Court case that we'll touch on here in a moment, we're expecting a few more things to drop. But I did want to just revisit some of what Governor J.B. Pritzker had to say on Monday in anticipation of responding to the Naperville plaintiffs for that Wednesday deadline. And again, we reviewed some of the top line arguments the state made in their filing that was made yesterday and came in at about 3 o'clock-ish or so our time. But here's the governor on Monday talking about why he thinks that ultimately they'll win in the U.S. Supreme Court.
There has to be a limit to the kinds of weapons that people can keep in their homes. And, you know, we have lots that are available to people, lots of weapons to protect yourself, and those that are available for sporting use. But guns that shoot, 30, 50, 100, bullets at a time are guns that people don't need to have in their homes for protection or for sporting use. And so I
do want to pause there. Does anybody in the chat know of a firearm that shoots 30 or 50 or 100 rounds at a time? What, like one trigger pull and then all of a sudden it's 50 rounds at one time, or 100 rounds at one time? There might be something in the military, like on a naval ship somewhere, that has something. I don't know. But anybody familiar with, 50 barrels that shoot at once? Again, the governor seeming to conflate hyperbolic concerns with what is legitimately being regulated in the state of Illinois with the ban on semi-automatic firearms. And again, people commenting here live saying, nope. Birdshot? Well, that's a good point, Joe. Interesting. I don't know, how many pellets are actually in a shotgun shell for birdshot, but that's interesting. Never seen one do that. Somebody else saying that the governor sounds ridiculous. Others saying nope. Of course, if you're watching us live, you can comment as the program proceeds. But back to the governor.
I'm hopeful that the Supreme Court will make a ruling that will recognize that the safety of our families is more important than people's desire to be able to shoot guns that really are weapons of war. Well, sure. Any time that more weapons are being purchased that are weapons of war that can shoot the kinds of rapid fire mechanism that can shoot rapid fire is dangerous for people. So, but I don't think that that's what will happen here. I know that I guess Coney Barrett is being petitioned for that. So we'll have to see. But I think in the long run that we will win at the Supreme Court. But are we concerned? Always a little bit, because you never know what the.
And then the governor, again, talking about how he doesn't know what the outcome is going to be. But obviously, you've got this case that was filed in the U.S. Supreme Court, Naperville Association, the Naperville case with the National Association for Gun Rights versus the city of Naperville and Illinois. And if you want to, you can go and read the filing from the state of Illinois that was filed yesterday. And as we did yesterday evening, we kind of just looked over the headlines here. The application is not shown that this court's likely to grant cert. Applicants have not shown that they are indisputably entitled to relief. It's not indisputably clear that the Second Amendment and ordinance regulates conduct protected by the Second Amendment. It's not indisputably clear that the act and ordinance are inconsistent with the nation's history of regulating firearms. And applicants' contrary arguments are not persuasive. No critical or exigent circumstance exists that would warrant an injunction pending further review. What's interesting there is they note that even the plaintiffs out of Naperville waited 2 weeks to file for an emergency injunction pending review, and that was denied by the Seventh Circuit while a review en banc full panel of the appeals court is still pending. So we'll be watching to see whether or not the full appeals court will take this case up. Again, we've got 3 weeks before the January 1st deadline, so a lot of things still possible to drop into place here. But we also want to take a look at the latest in the Caulkins case in front of the U.S. Supreme Court. So yesterday also, it wasn't just the Naperville case where there was action. You had action in the Caulkins case. So Friday, if you remember, the governor said that he was not going to respond to the allegations in Caulkins' case. Caulkins' case is a Second Amendment case, but it is also a case about conflicts of interest, and it uses previous Supreme Court precedents about justices in another state getting campaign contributions from a defendant. That defendant was a private party actor, not leaders of two of the legislative branches of state government. And that's something that when we talked with Jerry Stocks, it was a long conversation we had with him. I would encourage you to go check that out. But here's just some of what Stocks had to say when we chatted on Sunday.
Keep in mind what happened just approximately 2 weeks ago. The Illinois State Board of Elections, to my knowledge, confirmed a penalty against one of Senate President Harmon's counsel in the case for $99,500. I think pretty much a record, because of concealed independent campaign expenditures from an independent committee for the benefit of Justices Rochford and O'Brien. Now, it was concealed, meaning it wasn't reported timely. And prepare for this. $700,000 of the funding that I'm about to describe came from Harmon into this committee run by his counsel that contributed an additional $7.3 million to elect Justices Rochford and O'Brien. That is in addition to the $2.6 million from the defendants and their counsel that went to their election that we raised in our petition. Those are just the direct expenditures that went directly to the campaign funds of the judges where they could control the messaging. Well, the other 7.3 was non-disclosed, meaning the voters had no opportunity to know those expenditures that came from the committee controlled by Mr. Kaysen, one of the counsel appearing for Senate President Harmon, to the tune of $7.3 million. A lot of the gifting was what we call split reporting, where they're running television ads a committee called All for Justice. I just learned this. Tomorrow or Tuesday, depending when it gets back from the publisher, we will be filing a supplement to our petition, raising these issues and pointing out this newly discovered material.
And Stocks did indeed file that supplemental, and you can look at that yourself on the docket for the Caulkins case, where he lays out in a supplemental brief even more detail about the questions of how much campaign funding went to these two Supreme Court justice candidates. But the case that he's ultimately using as precedent is the Caperton v. Massey case. And he talked about how that dealt with sizable campaign contributions, but the campaign contributions in Illinois to two Supreme Court justice candidates coming from the leaders of the two other branches of government, the executive and the legislative branch, giving campaign funds to candidates for the judicial branch, the state's highest court. He says that is magnitudes more serious than what the Caperton v. Massey challenge was all about.
So, in terms of magnitude, this is just the money, all right? And Caperton was just money. We are Caperton by magnitudes on the money, but we have evidence of a shared commitment to a specific outcome with the contributing defendants, who are also the leaders of the other branches of government. The significance of that shared commitment, it wasn't just an expression of judicial philosophy. I mean, a judicial candidate, they have free speech rights and campaign rights, and we're not even in that realm. They specifically signed off or allowed themselves to be represented to the public as signing off on a specific outcome of an assault weapons ban. And here, this next phrase is significant. When the General Assembly reconvened. Not only were they pledging themselves to an assault weapons ban, they were pledging themselves to the process by which it would come to pass and the immediacy by which they expected it to come to pass. And it all played out that way. And then we get to a third level that is absent in Caperton, and that was intolerable. Here, we have the leadership of the other branches of government that are the ones contributing these funds, sharing these commitments. And that strikes at the heart and core of the independence of the judiciary, a de facto dissolution of separation of powers under our state constitution. And it's the classic Illinois story. Outrageous, stinks to high heaven, and another chapter of blatant disregard for the rule of law and the rights of citizens in this state. Here,
so again, Jerry Stocks talking about the case and where ultimately we go from here. The question is going to be in front of the U.S. Supreme Court, because what you have is Justice Amy Coney Barrett, after getting the state's response that they're not going to respond to the Caulkins case. Jerry, he filed a supplemental brief with more detail about the campaign spending. And then on yesterday, Justice Amy Coney Barrett distributed the case for conference to the rest of the Supreme Court for their conference on January 5th. Now, I know that that's after the January 1st deadline to register. Keep in mind, you still got the Naperville case that could be dealing with the direct question about the Second Amendment. The Caulkins case really deals with the issue of, not just the Second Amendment, which is central to the case, but also the conflicts of interest. So I think that that's a distinguishable difference that the Supreme Court could possibly take up, especially with them now sending it to conference for January 5th. But if you recall, back in March, I asked Governor J.B. Pritzker to explain his $1 million donations to then Supreme Court Justice candidates Elizabeth Rochford and Mary O'Brien. Here's what the governor had to say.
Something that the right wing is trying to stir up. I know you've written about it. The fact of the matter is I supported candidates who are running all across the board. If you're suggesting that the fact that I gave money to, let's say, the Democratic Party or to the committees that supported candidates means that everybody who received any money has to recuse themselves from anything to do with the state of Illinois, that's ridiculous. And I've certainly never asked anybody to vote a certain way or decide on a case a certain way. I would never do that. I never have. I never will. And these are independent judges, and they didn't go around and campaign on things, that they thought would win my support for them. I believe in them. I supported them like lots of other people did.
Again, he says that they're independent candidates, independent judges, but as Stock says, there's evidence suggesting that they had a political alignment on a goal to pass a ban on semi-automatic firearms when the legislature reconvenes. Back to Stocks.
The political end, the context for all of their action is stripping a fundamental constitutional right in the form of the Second Amendment. I mean, they're just not doing this so that they can favor a private litigant wanting to avoid a punitive damage judgment like some of our precedent State Farm case and things that were thrown at us before the Supreme Court of Illinois. This is something far more pervasive, fundamental, and strikes at the heart of the very legitimacy of our institutions in this state.
Clearly, we'll be watching that case closely as well. Bishop on air with you. Thanks for hanging out. We've got more to get to. Be sure to like, subscribe, follow along on Twitter, X, Facebook, YouTube. Be sure to also check out the store if you want to support the program further. You can do so. But appreciate you guys tuning in as always. And let's continue on. All right. It is Bishop on air. Anywhere, just search Bishop on Air.